For those of you who don't know, my name is Eli. I am the legal support coordinator here at VIP. We are here today with Kate, and Lindsay is going to be helping to talk about wills versus deed transfers. Here at VIP, this is a subject that comes up pretty often for our clients. And we tend to steer them towards estate planning and the will option rather than the deed transfer, just because of our own priorities as an organization. But we wanted to talk about the option of a deed transfer and talk about scenarios in which that might be a better option for clients, and to discuss the analysis that will help you to make that decision for your clients. We do want to make this a discussion, so please do speak up if you have questions that you'd like to ask. I will put the scenarios up so everyone is able to read them as we go through them, but otherwise, Kate, I will let you sort of take over in talking us through that first analysis.
Thanks, Eli. Hi, everyone. My name is Kate Van Gradis. I'm an attorney at Community Legal Services. I work in both the SSI unit as well as the Health and Independence unit, which covers a really broad range of public benefits, including Medicaid long-term care, which is very, very much tied into this. So I'm going to be kind of coming at this analysis from the perspective of how these actions could impact public benefits and how to best meet the client's needs and what they're hoping to do, and talking through what their options are. And then I know Lindsay is going to be able to talk a little bit more about things like probate and some issues around how marriage impacts stuff, which is a little outside of my area of expertise, because we are not generalists when it comes to things like home ownership. So I guess to start with the first scenario, I'll say also all of these are scenarios we see really frequently. Fortunately, people often are proactively thinking about how to address these issues. Sometimes we get them on the other end when transfers have already been made or services have been received and people are concerned about how this will impact their family and their home ownership. But this especially, I'd say, is one we see quite a bit. So the first scenario, we're looking at an 89-year-old client, 2 adult sons, and the client's concern is avoiding probate. She owns her home. The home is just in her name and her deceased husband's name, which I guess Lindsay will talk a little bit more about in terms of how this passes to her adult children. There's a home equity loan. So we're looking at the value of the home for many perspectives being impacted by what is left on the loan. And our only source of income is $872 from SSI. So the things that are a flag to me here is that the concern for the client is that she wants to avoid probate. So I would probably ask her a lot more about what the desire is to avoid probate. It does, from my limited knowledge, it's not simple. It involves some work on the part of the people involved with administering the estate. And that could kind of be it, or her concern could really be about her home being impacted. So the things that we would look at here from a benefit perspective is that she is receiving SSI, which is a means tested program through the Social Security Administration. It is distinct from Social Security retirement or disability benefits in that SSI, which is through Title 16, has very, very strict income limits and resource limits. And it also has penalties over what you do with the things that you own. And if you transfer assets, which is really considered anything that you have that kind of could be, that has value, that could be used to barter, to sell, to buy. Assets is assigned very, very broadly and does include a home. If you transfer an asset for less than fair market value, your SSI benefits could be at jeopardy of being suspended, which if a suspension lasts for more than 12 months, your benefits could be terminated. this is an 89-year-old adult, so that's the suspension versus termination thing is probably a little too in the weeds. She's likely receiving SSI due to her age, but there is a concern if she added her children to this property without her children paying her fair market value for the ownership interest she's transferring. That would be considered a transfer for less than fair market value, and it could invoke a penalty period. A penalty period for SSI is the amount, they look at the amount that's transferred for less than fair market value, and they divide it by the federal benefit rate, the maximum, which is currently $872. So that could probably be a pretty long penalty period, depending on what the value of the home is. We know that there's a loan. She has about 10 grand to pay off, so we'd have to factor that in. But that's definitely a big concern. There's lots of exceptions and ways around the transfer of penalty for SSI, so we'd be able to talk through that. Mainly what Social Security is concerned with is that someone is transferring assets in order to qualify for SSI. Here, this is the home she lives in. You're allowed to have one home and still receive SSI. You can't have non-residential property and still likely be under the asset limit, which is only $2,000. But here it's a concern about avoiding probate. So technically that is an exception. She's not doing it to qualify for SSI, but I can guarantee you that this would raise red flags. And the last thing you want is to add stress to this 89-year-old client's life. So this is really something to talk to that we would probably want to try to find ways to proactively get in front of, in terms of having things approved by the Social Security office, making sure that they will not then say, you transferred property, we're going to suspend your benefits for however many months. There's other exceptions, including transferring property to family members. So we would see if her children could qualify as falling under those exceptions. They generally relate to family members who live in the home, or disabled or minor children. So that might be tricky here. These are adult sons and they don't live with her. And then also if it's an undue hardship. So this would obviously be an undue hardship if they cut off all of her SSI. It's her only source of income. That would probably be another way around this penalty period. But as anyone who's dealt with Social Security knows, it's not, that nothing is a guarantee, and it's difficult. And so you really want to talk through these, figure out what the best argument is, and find a way to make sure it's okay with Social Security, likely before anything happens. Of course, often clients come to you and they've already added people to their deeds or transferred assets, but here we have a best case scenario. So that is at least the SSI perspective. I don't think we necessarily, the other thing we'll flag, which I know we're talking about probably more in the other scenarios, any transfer for less than fair market value will also be scrutinized if this client applies for long-term care Medicaid. Because when you do that, they require 5 years of bank statements to look back to see if you've disposed of any assets. And they also ask if you have transferred property for less than fair market value or sold any property. There are ways to get around the penalty period that do involve transferring property to family members. At quick glance, it doesn't appear that these kids would necessarily qualify unless we have more facts. So we'd want to ask more about have they been providing care to their mom so that she can remain in her home, but to really squarely fit within those requirements, which I think might be easier to talk through within another scenario, since I know I've gone on and on about this one already. But those are other things to flag that we're I'm thinking about two different types of public benefits: SSI through the Social Security Administration, and Medicaid long-term care, which is administered by the Pennsylvania Department of Human Services, currently through 3 managed care organizations and community health choices, and transferring assets, which includes transferring your ownership interest through adding people to a deed, are flags there, and things we're going to want to ask a lot more questions about, which these scenarios will elucidate.
And so I'll talk a little bit in this scenario about the counseling that VIP would likely do before we would refer the case out to you as a volunteer. So it's not necessarily that if you take a VIP case, you're ever going to get a scenario like this, because likely we would have done some of this counseling in advance. But sometimes clients, come in for estate planning, we prepare an estate planning case, and then when they get referred to you, they might have some questions about, oh, well, I heard from a neighbor that it's better to avoid the probate process. So is that something that we should discuss? And, as Eli mentioned in the beginning, our general feeling is that it's probably better to do estate planning in this scenario, particularly for the reasons that Kate already mentioned. But, we're also looking at a few other issues that we would want to counsel the client on. And we would never tell absolutely, the client legally can add her 2 adult sons to title. It might not be something that we at VIP want to assist with and use our resources towards, but it's absolutely something that she could legally do. The question is really, is it a good idea? And in the counseling with her, is it something she decides that she wants to go forward with? Or does she learn some things from our counseling that makes her realize that it probably would be better to go the estate planning route? So title is currently in her and her deceased husband's name. So one thing that we could help her do is a deed of confirmation so that title is only in her name. It is likely, since they were married, that they owned the property as tenants by the entirety, so that when her husband passed away, title transferred automatically to her by right of law, and all that would be needed would be a deed of confirmation stating that. But I would want to look at her current deed to make sure that they in fact did own the property as husband and wife, and it was clear, and it wasn't a situation where they were commonly, she was expressing that they were married, but they were in fact common law married, and maybe the deed doesn't reflect that, or she owned the property before, one of them owned the property before they got married, because to be tenants by the entirety, you have to be married at the time when you take title. So, we would have some of those questions. We would want to know exactly how she held title. She lives alone in the home. So these 2 adult sons, we would want to know more about why she's trying to avoid probate. Is she trying to avoid probate just because she's heard it's a really complicated process? Well, yes, it is. In some ways, it's not that difficult if her 2 sons are her only heirs, and she doesn't have other children or children who passed away and have children and estranged spouses or a whole big family tree. If it really is just her 2 sons, maybe it would not be so difficult to go through the probate process. And certainly if she drafts a will, it will not be as big of a deal to go through the probate process. There are some costs associated with it, but those costs might be worthwhile rather than, some of the risks, like getting cut off from her SSI, like being ineligible for medical assistance. The mortgage company, she has a home equity loan. Is there some kind of acceleration clause in that home equity loan that would prevent her from adding people to title? Would it make her ineligible for some programs that she's already qualified in if she was in an owner-occupied payment agreement for her back real estate taxes, or if she was in LOOP, the long-term owner-occupied payment agreement for property taxes, if she was going to try to apply for basic systems repair? All of those programs require someone to be a low income owner occupant. And so if the adult sons are on title, she wouldn't, 1, because they're not living in the property, 2, their incomes would have to be considered, and 3, she would have to get them to sign off on anything. So she also loses some control over her property. And it can be a difficult conversation to have with clients, but if you add people to title and then a disagreement comes up, they could, at some point force a partition action, or, she could lose her home by adding people and losing the control that she has over the property. So there are lots of different things to consider when this kind of scenario comes up. And a very simple way to handle the situation is estate planning. So when we encourage people to do estate planning, It's thinking through exactly who they want to inherit their property and, you know, putting that out in a will and having it properly executed. And that solves a lot of the issues that might come up otherwise. That being said, if, you know, we have this conversation with this 89-year-old client and she really convinces us of why her 2 adult sons should be on title, you know, that is her call as the client. But again, it doesn't mean that we at VIP necessarily will go forward and do that case. It has to be something that we feel comfortable with, that we're not putting her in a dangerous situation. Otherwise, you know, we have resources where we can recommend clients to go for a private attorney, and she can go through that process a different way. But I think those are sort of all the key points that I see when looking at this scenario. And the balance on this one to me comes out that it's not worth her adding people to title when she has so much at risk. And particularly because she's 89, and as Kate said, we will talk more about medical assistance, but that could be a real barrier for her. Does anybody have any questions or thoughts about this scenario, or different type of counseling that you might do if you were the attorney?
I have a question that might be related. You mentioned a deed of confirmation. Why would a deed of confirmation be necessary? I have a situation where I have what were 2 sisters and the daughter of one of those sisters on a deed. The mother sister passed away, so now it's in the hands of you know, the aunt and the niece, and everybody's happy. Is it necessary for me to do a deed of confirmation in that sort of situation, or why would it be advisable? As well as joint tenants or the right of survivorship.
With right of survivorship, it's definitely not necessary. Some of our clients have found when they're applying for different programs that it really helps to have that deceased person off title. And a deed of confirmation is easy. It doesn't have transfer taxes. There's no issue with doing it. It is a little easier when they're husband and wife, because then no inheritance taxes due. You know, there might not be a benefit of doing that deed of confirmation, okay, but it could make it simpler for them in the long run to have that deceased person off title.
Okay, that makes a lot of sense. I appreciate that.
Yeah, absolutely.
Hey, I have a question.
Sure.
For both Lindsay and Kate, with this scenario, when would it be appropriate to have the client transfer title but reserve a life estate for herself in the property? That seems to come up a lot, just reserving life estates. So I'm not sure if that affects the disability benefits or if it affects Medicare or what. So any thoughts on that? And I'm gonna go back to my lunch.
I will just say that the only thing that matters when looking at this in terms of transfer for the impact on benefits is how much the value is. The type of what you transfer actually does not matter. It's just the valuation. And I don't know how you would value a life estate transfer. It's never come up for us. I don't know if Lindsay knows more about that, but it's really just the issue of what is the fair market of what you are transferring, and is someone giving that to you in exchange for that? Is consideration paid?
So maybe in that scenario, it wouldn't, I don't know the answer to this, but maybe it wouldn't matter as much for SSI, but it might matter for medical assistance, because the value for medical assistance is, you know, what type of estate recovery can happen after the person has passed away. And if they've given away that, I think the consideration would have to be a lot higher for that scenario, if that makes sense.
That's helpful. Thank you.
Because I think the consideration is really like, what control does that person have over the property, and what rights are they giving up? And if you're giving up the right to transfer it after you pass away, I have a feeling DHS would still want to do a state recovery, and then it might prevent her from being eligible for medical assistance. But I am not an expert in that area.
I would say it's never come up in this type of scenario. If someone determined that reserving the life estate for themselves was something that they felt really comfortable with in these circumstances, we would consult with a DHS, someone from the Office of General Counsel. They will review facts and say whether or not they would approve it or not, and then we're able to have those letters and attach them to the file and make sure that the family has it if later the Department of Human Services files a claim against them to try to recover the money that was spent on this person for their Medicaid long-term care. And I think if you could really show that that the purpose of this was not to qualify for Medicaid long-term care, this wasn't sort of a spend down in disguise, that this person had excess resources and they were trying to spend down to the limit, it would probably be okay. But it's not something that I'd say, oh, 100% there'd be no issue. I think it would still raise the specter of concern. An exception to a transfer penalty that could impact things if she was applying for benefits would be to say for both SSI and Medicaid that this was not for the purpose of qualifying for benefits. It just puts the burden then on your client, which, as anyone who's dealt with DHS or SSI knows, is just difficult, but definitely possible.
Thank you.
I will say that I don't think the life estate would prevent someone from being eligible for like a city tax program or repair program. So in that way, it might be okay. But in this scenario, it might come up with the mortgage company. I think you would probably want to reach out to the mortgage company first to make sure that it would comply with the mortgage requirements.
I think that's a good transition into our second scenario, which does involve medical assistance. I'll read it out for everyone. 86-year-old client in hospice care wants to transfer title to her son so she can be sure he has a place to live after she passes away. Title is currently under both client and her deceased husband's names, tenants by the entirety. She was estranged from her husband, but not divorced at the time of his death. There is no mortgage or other liens on the property, and she is living alone at home. Her sources of income, her source of income is $900 a month from Social Security disability, and then she also is receiving medical assistance through DHS.
Lindsay, do you want me to start or do you want to go first?
Well, I can just say, a lot of the analysis is the same here from the title perspective. She wants to transfer title to her son so she can be sure he has a place to live, but he's not currently living there. So, I think maybe our analysis would feel a little, change the facts a little bit. He's living there, he's taking care of her. I think that changes things a little bit, but if he's not living there, again, I think our general tact would be to encourage estate planning. And I think the medical assistance piece is going to be the main thing that we talk about in this scenario. So I will turn it over to you, Kate.
Yep. So we got, in terms of the benefits she receives, we know she's getting Social Security disability. We know it's not just SSI because it's over the federal benefit maximum. It's $900 a month. She could be receiving both, which could really complicate things, but just for the sake of this, let's just say likely this is just Social Security disability only, which means that there is no income or resource limit. There's no issue with transferring assets, which makes our lives a lot easier. But we do know she's receiving medical assistance. It appears from what we can tell from these facts that she may just be receiving hospice care at home. But if she's receiving long-term care in her home through medical assistance, then we do have a flag. So the thing that's a little weird here is that you can get hospice through Medicare primarily. Medicaid does cover some, but it's pretty limited. And it's also possible to be receiving long-term care. And then as the terminal illness progresses or that diagnosis is received and hospice care becomes required, to have both. So when we say Medicaid long-term care, there's really two ways you can receive that in Pennsylvania, either in a nursing home or receiving home and community-based services in your own home, which we also call waiver services. The program that administers them, it's the same. It's all through Community Health Choices. There's 3 managed care organizations that then directly provide the care. So here I'd really want to know exactly what the client is receiving. Does she have regular Medicaid? And when we say regular, there's still many categories based on age and other things, but just covering her physical and mental health benefits, or does she have long-term care Medicaid? The reason we want to know is because if she has long-term care Medicaid and she transfers any assets for less than fair market value, it can trigger this penalty period. Unlike with SSI that we were discussing before, the penalty period for transfer of assets for less than fair market when you're receiving long-term care Medicaid is the amount that you transfer for less than fair market value divided by the average cost of a private pay nursing home in Pennsylvania per month, which in 2022 is around $11,000. And that would mean that for the period of time, however many months that is, she would be without that benefit, which could be really, really detrimental. Obviously, this person clearly has very significant health needs if they're in end of life, and they would definitely need that to be covered, and the cost would likely be absolutely astronomical. However, we also know that the concern here is transferring to her son. And so when we think of who is she transferring it to, and we need to know more about that person, it says that she does not currently, or we're not sure if she lives with him. But if she's living with him and she has been receiving waiver services, these long-term care services at home, that might be an exception in terms of the transfer. If he's providing this care for her while she's receiving services, essentially that's really allowing her to remain at home. That could go towards being an exception to this transfer, but you would need to have evidence that the son has been doing this, likely from neighbors, friends or family or doctors. And also you would need, she needs to be receiving services for 2 years while he's providing this care. It's very strict rules. Alternatively, if it turns out that the son has any type of disability that qualifies him for Social Security benefits, she can transfer ownership interest in the home to him, and it is an exception from the penalty period. If it turns out that she's not yet receiving Medicaid long-term care, I would say here that because she's in hospice care, I don't know if this would be really like the most likely thing to occur, just because hospice care is usually not lasting for very long because the person's life is ending. But that is another consideration, because if she then wanted to apply for long-term care Medicaid, they would look back at this transfer and have questions about it. And again, it's possible that there are factors here that could go towards it being okay in terms of the son caring for her, or the son having a disability, which are things that are both in the statute for the transfer penalty and for estate recovery, which I know we're kind of straddling all these different worlds of how this factors in. Meaning if she was to do nothing and she passes away and she's been receiving long-term care services, the state can come to her son afterwards and say, hey, your mom was receiving services. We realize we have this claim for $400,000 against her because we provided all of this Medicaid care for her. We're going to seek to recover that from the value of her estate, which for most people does primarily include their home. And he would be able to likely request a hardship waiver if he met some of the requirements we just talked about, which is living in the home while she was receiving care and providing care for her, and he has no other place to live and all of this, or if he is an individual with a disability. That also allows you to have a postponement of the medical assistance estate recovery. So there's a lot of different things to factor in. I know I'm saying a lot of different terms, in terms of how the analysis changes. But the things that are really key to me here are, does the son live with her? Has he been providing care? What type of medical assistance is she receiving? What type might she need? Does the son have any disabilities? Just learning a little bit more about the family. Oh, it does say she's living alone. Okay, while receiving care. Is he even coming by and providing care? Because sometimes even when things don't fit perfectly within the statute or the regulations, if you can provide compelling evidence, which is often the situation we're in, DHS and their attorneys will bless the transfer or exempt it from a state recovery.
And in this case, it looks like, all she cares about is him having a place to live after she passes away, and that can be accomplished by a will. As Kate mentioned, he might have to worry about estate recovery afterwards, but he's going to have to worry about that whether he has title or not, probably, because she has been receiving these services. So if all it is making sure he has a place to live, a will is the way to do that, or one of the ways to do that. But it's certainly one that I think we would encourage in this situation, again, because of how complicated some of the benefits issues for her are. And again, we want her to have control over her property while she's still alive and living there.
One thing I will add is that a will does not prevent estate recovery from taking place, which is the most frustrating, I think, issue that people really kind of come across when dealing with this. In the statute, there's the order of how the proceeds are distributed from an estate, and it having a will does not protect your property from estate recovery, unfortunately, which is why we look at the exceptions and the waivers and the deferrals.
And there is this little fun fact in here that client was estranged from her husband, but not divorced, which in this case is really beneficial, because if they had been divorced and not dealt with the property in their divorce, their title as tenants by the entirety would have changed to tenants in common. And then we would have had to worry about who his heirs were when he died. But since they were not divorced, we don't have to worry about that. Client is the sole legal owner of the property. Anybody have any questions or thoughts about this scenario? Not, we can move on to the next one.
Oh, I'm sorry. I looked this up specifically to be prepared and I completely forgot to mention it. Hospice care is not long-term care. I think that was kind of like embedded in what I said, but I wanted to be clear. When we say long-term care, it's just the nursing home and the home and community-based services, and also the cost of the care related to that if someone's living in a nursing home. But hospice care itself is not considered long-term care. So it alone, that does not trigger a state recovery or any other transfer issues.
All right, so scenario number 3, this time we have a 71-year-old client, and her concern is her reason for wanting to add her daughter to title is to avoid probate and inheritance taxes. She again lives alone, so her daughter's not with her, and title right now is only in her name. Her daughter, though, does help her to maintain the home, paying bills, cleaning, etc. And client's only source of income is $850 a month from Social Security. I will leave it to you, Kate.
I can talk a little bit first about, what this means about avoiding probate and inheritance tax. So as I mentioned earlier, people do find probate difficult, but it can be broken down into just a few steps where, particularly if someone has a will, you take the will to the Register of Wills, and there is a filing fee. For most of our clients, it's in the $400 to $500 range. And if the property is transferring from mother to daughter or even to anyone by will, there's going to be no transfer taxes when the new deed is recorded. So once you open the estate at the Register of Wills and pay that filing fee, you have to file an inventory. You can then distribute the assets, and you have to file and pay an inheritance tax return. Excuse me. So the inheritance taxes can certainly be expensive depending on the value of the estate. But if the daughter is on title with her mom, even as joint tenants with right of survivorship, when the mom passes away, she wouldn't have to probate her estate, but technically inheritance tax is still due. So she is not avoiding inheritance tax by adding her daughter to title, even as joint tenants with right of survivorship. And if she completely transfers title to her daughter who's not living there, she's really making herself ineligible for repair programs, tax programs, the programs that the city and utility companies offer to owner occupants. It also would make me personally very nervous to recommend that anyone take themselves off title to the home that they live in, because her daughter could decide to rent it out, to kick her out, to sell the property. It just is not necessarily worth it. Now, that again it's a decision for the client to make. And I think when I turn it over to Kate and she talks about it a little bit, 71-year-old, the analysis is a little different than an 86-year-old who's on hospice. So there are certainly those considerations, but again, in this scenario, I still feel like I would be recommending that someone really consider estate planning and would want to know more about why they want to avoid the probate process, maybe explain the probate process, and also really hit home that she's not avoiding inheritance tax if they go on title together.
Yes, the age, as Lindsay said here, is a really big thing to focus on, because a 71-year-old who lives alone in her home and is probably still pretty independent has to be thinking ahead of what might happen. So if a 71-year-old was at CLS and expressing these types of concerns, we would really want to let her know that if she applies for Medicaid long-term care, if something happens in terms of, we would ask more about her current health, but also to let her know, even if she's healthy now, if anything happens and she does require long-term care, there is this 5-year look-back period. So the Department of Human Services requires bank statements for the past 5 years, and also will look at any of these transfer of assets and then delve into them the way that we've been talking about it. And I guess why that really matters is because it could delay receipt of her necessary benefits in terms of long-term care. And just given the astronomical cost of long-term care, which I'm sure everyone's aware of, even for people who are more sort of like middle income, it can be absolutely devastating to try to do private pay nursing home. I mean, as we said, it's about $11,000 a month is the average in the state. So it can very, very quickly drain resources. So there is this concern about both preserving this family home and also the receipt of long-term care Medicaid. And so we would talk through some of the ways that she could try to maybe protect the home from estate recovery, which includes if her daughter does move in with her, if she does provide care, if some of those things that we had talked about and how to structure that in a way. But really the knowledge that that transfer could be a big, big issue in terms of that, and just not knowing what would happen in the next 5 years. And we know that also she has, it says $850 a month from SSI. So if it's SSI Title 16, again, transfer of any asset, again, would be an issue. And I know we've talked through, I've kind of listed a couple of ways that you can have an exception around that, but that it is something to deal with. And I would say probably just as a side note, more than ever, Social Security is really, really hard to communicate with right now. The offices have been closed for almost 2 years because of COVID, and now some sort of labor-related union agreements about the return to office. And so communicating with the Social Security Administration, getting someone on the phone, getting appointments in person is really, really, really hard. And so the chance of her benefits being negatively impacted by a transfer of title or giving away part of her title and adding her daughter could be really, really detrimental to her income. So you would really want to make sure to figure out how that would fit in, make sure everything is okay, and that she's not going to have a disruption to her income.
And Kate and I were talking about this when we were talking about this training, but both of us have had experiences where clients, where SSI, they are watching, they are checking Office of Property Assessment, I think is where they really pull information from, because I had a client whose deed was misindexed, and then that information was put on the Office of Property Assessment website. We had the deed properly indexed, but the Office of Property Assessment was way behind in fixing their records. And Social Security Administration was cutting off our clients' SSI because they said he owned 2 properties, and he didn't. He only owned 1 property. There was just a misindexing issue, and the Office of Property Assessment improperly had a property labeled to him. So and it happened really quickly. So it is not something that, oh, we can record this deed and Social Security is not going to find out about it. They actually are looking at the records.
Yeah. They use data matching systems now through Accurate. And when they get hits, they're required to investigate what's happened to really clarify it. But in practice, we're seeing it just leads to a suspension. From the date of a suspension notice, the person has 15 days to appeal to continue to receive their benefits at the current level. Given mail delays and other issues with just people opening their mail, the chance that that doesn't happen is scary. You really can get 65 days because of current ongoing settlements related to a Second Circuit litigation, but I just wouldn't want to even mess with it. It's the risk of even going a couple weeks without income when your income is that low is incredibly detrimental. So this is something we want to be very, very cautious and proactive about.
Right. And I think we have time for one more scenario. Here, a 65-year-old client wants to make sure her son always has a place to live. She does live with her son, but is the sole person on title. She also has 2 daughters who don't live with her, and she is currently receiving $900 a month from Social Security Disability, as well as $600 a month from a pension or retirement fund.
I feel like I'm making a face because whenever there's multiple family members, things get messy, as I'm sure anyone who's done any of these types of cases or estate planning or anything knows. Client lives with her son, so question really is he providing any care? Is she receiving any services? Does he have any disabilities? Those are all really important things to be on the lookout for, sort of for any of our analysis in terms of transfer or estate recovery or any of those things. Because if he's living there and he does fit into those categories, either that he's providing care and she's receiving long-term services, or that he has a disability, she can transfer the asset and we don't need to worry about penalties. Or they could probably easily get a hardship waiver once she passes. The 2 daughters living on their own, I would just say when we are counseling the client, it's just really important to make sure you remember who your client is. These cases, that gets really, really messy around. We've had to have a lot of conversations with older adults where we say, I know you really, really love your kids and you trust them, but as your attorney who's looking out for your interests, I just need to make sure that I'm clear on what you want, what you need, what your wishes and desires are, because these can become really wrapped up and complicated with adult children. And I will pass it to Lindsay. And I'll again say Social Security, disability, pension, no transfer issues there, which is always good.
And, you know, with the son living in the home, it does make a difference from the perspective of city programs as well. The son's living there, so any income that he has is going towards their household income and would be relevant to her application for these programs. For most of them anyway. So she's probably not harming herself by adding to him to title if he's there living with her in that respect. But she is giving up control of the property. And you know, we've had situations where clients have added someone to title and then come back to us and say, I mean, we didn't add them to title, but before they came to us, you know, added a son to title because he was living with her, but then he moves out, a daughter moves in, and now she says, okay, well, I want my son off title, but my daughter on title. And the question then is, okay, but is your son willing to give up title? You know, he has to sign the deed. Once you add him to the title, you can't take him off title unless he agrees to it. If you draft a will, you can leave your property to your son. And if something changes in your life, you can rip up that will and draft another will that would then replace the son with the daughter. So, you know, it feels a little bit like a broken record to say it, but again, my counseling would be to really think through why, you know, the safest way to guarantee that her son always has a place to live is to draft a will, giving him title for when she passes away. It leaves her with control over the property. It gives him that place to live and the inheritance when she passes away. And she can also consider leaving other things to her daughters by that will. She could get in her will, she could give her son a life estate in the property and have the daughters as remaindermen, so they're not completely written out of the will. Or, you know, there's a lot of different ways she could draft a will that gives her some more flexibility. But if she transferred title, it would really be a final decision. So, you know, I think there are certainly situations where it makes sense to transfer title, and this could be one of them. Particularly, I mean, she has a disability, but she's, you know, in the younger range, maybe, and her son is living there. Maybe he's taking care of her. Maybe he has a disability. So all the things that Kate's been talking about, it could be the situation where maybe it does make sense to add him to title. But it would be a pretty thorough discussion with the client, making sure to counsel her on all of the different pros and cons, and then deciding whether, you know, you as an attorney are comfortable with the decision she's made, whether you send her somewhere else to, you know, to carry out those wishes, or whether it's something you feel comfortable doing. And, you know, I will just say, as a VIP volunteer, you know, we want to help you have these conversations. So if a case gets through to you where you were expecting just a simple will or a simple deed transfer, and some of these issues come up, it's absolutely something that we want to talk with you about. We want to talk through. We can have, you know, a conference call with you and the client, and just talk about all the different scenarios, make sure that the counseling happens. And then sometimes it could be that we close the case. Sometimes it could be that the scope of representation changes, and you're either comfortable doing that and change your representation agreement, or not comfortable doing that, and we take the case back. But it is really important to have these conversations. And so that's why we wanted to start this discussion. And certainly there are many other issues that could come up, or different scenarios, but we're very grateful to be having these conversations. And Kate, I just want to say thank you so much for all of your insight. So I think, you know, those are all of the scenarios that we're going to talk about today, but does anybody else have any questions or want to talk through any issues?
I have two quick things to say about estate recovery if we have time, but I don't want to take away from questions.
I had a
James,
question.
did you have a question?
I had a question, if that's okay. I think it's a pretty quick question. So we see a lot of Spanish speaking clients and I guess it's more of a basic question. Is there, I guess one, as far as like the actual documents themselves, in order to be legal, do they have to be in English? And then two, maybe sort of a sub question is, if they do have to be in English, is it helpful? Is there a way to sort of include a Spanish version so that there's no contesting that, well, this person didn't necessarily understand because the document's in English?
Are you talking about for a will?
Yeah, yes.
What we tend to do at VIP, I've seen different ways of doing it, but we tend to have the will in English, which is the executed notarized copy, and we attach a Spanish translation to it. Our living will actually goes paragraph by paragraph, so it has like the English, the Spanish, the English, the Spanish. So that could be another way, but I don't 100% know the answer to this, but I would imagine that the Register of Wills, when they're accepting the will, does not want to see the Spanish version. And so, yes, it should be in English and it should be signed and notarized, but that counseling piece to make sure that the client understands what they're signing, and having a translation, I think, is an important piece as well.
Thank you.
Any other questions? Kate, do you want to talk about estate recovery?
Sure. I will
More?
also say that fortunately, while Department of Human Services is not always the best with translating materials, on their estate recovery website, they do have a really comprehensive brochure about the program with questions and answers that are pretty easy to digest, and it comes in Spanish as well, which is really helpful. So I am glad to direct people to that. The only point I was going to say is I wanted to make sure when we talk about wills, deeds, the one thing I forgot to specify is that estate recovery only does not apply to properties where it is tenancy by the entireties or joint tenancy with the right of survivorship. I know we talked through a little bit about those different types of deeds, but there's so many parts to this. I wanted to make sure to clarify that. So one thing that we have seen where it's appropriate to have a transfer is to make sure that the deed language, for example, if it's a parent and child, is joint tenancy with the right of survivorship. That is really, really crucial. That will completely exempt it from estate recovery. The other point was really just a little bit more of a soapbox in that this is part of Medicaid estate recovery when we talk about what happens to the property after the person who's received long-term care passes away. Nothing happens during their life, but when they pass, it often means that their family's wealth in the form of their home is completely threatened. This has a very inequitable effect on low-income communities, especially people of color. There have been movements in the recent years to stop this act, and there's some really good resources. I'll put one in the chat about how this perpetuates poverty and inequality and how states actually don't recover much money. It really just has a lot of administrative costs. It is incredibly disruptive. It often means kicking people out of their families' homes that they've had for generations. And there was an act that was introduced last Friday by a representative to stop the Unfair Medicaid Recoveries Act. So it's something I encourage people to learn more about because most people don't know that this happens. And it is absolutely devastating for families to learn that their home could be threatened because their family member needed long-term care.
And I'll add that I think Jasper Katz is on this call, I believe. And Jasper is running a group. Jasper, I don't know if you want to talk about the goals of the group, but talking local Philadelphia legal aid agencies getting together to talk about just this, getting rid of estate recovery, and or even in the alternative, if that doesn't happen, working to make the process better, clearer for clients, because there also is a lot of misinformation about estate recovery. And I've had some clients mention to me that they were considering not getting long-term medical assistance, even though they needed it, because they were scared that they were going to lose their home over it. And so there's also while it is a real threat, there's also some misinformation about it. And so it's important to be having these discussions. So I'm sure if anybody wants to join that group, we're talking about these issues as a Philadelphia legal community.
Yeah, I don't have anything to add to that, Lindsay. I think you covered it.
Well, excellent. Thank you for Jasper to getting us all on the same page about that.
I had a question. I often see deeds that are held in trust for other people. Does having a deed held in trust for an heir or a family member, is that an exemption from estate recovery, or could that be like a strategy to avoid estate recovery after someone's death?
We're actually trying to get information about that. The person who made that determination at DHS apparently used to believe that a property held in trust actually was not an excludable asset. And so someone would not have been eligible to even start getting the medical assistance when they had this property in trust because they would be over asset. And so, but I haven't spoken to anybody who actually knows the answer of what the current protocol is. I had been speaking with Pam Walls about that, but I don't know, Kate, if you have any other thoughts about it.
I haven't heard any updates or clarification around that. It is a really tricky area. I will say that transferring an asset to a trust can protect it in terms of being a transfer that would affect SSI. If it's a trust for a disabled or blind child or somebody who's disabled or blind and under 65. So it is possible to put assets into trusts and that transfer is not going to hurt your SSI. But yeah, in terms of estate recovery, I don't think we feel I would not confidently tell someone that that would shield it from estate recovery. Especially if I think the analysis really does, for at least from my understanding and discussions with DHS attorneys, is the purpose to avoid estate recovery, because if there's no other explanation, I think they will be very unlikely to exclude it. And I don't think the statute is clear from what I've looked at, but I could be wrong.
Well, we just hit 1 o'clock, so Eli and I are happy to stay on and keep the chat open, but we want to thank you all for attending today. And Kate, thank you so much for your information and joining us. And thank you all for your questions and thoughtfulness in attending. And for those of you who are interested in taking a case, we will be following up with you. We really appreciate that you are reaching out to us, attending these programs, and hopefully we will get you the right case and that none of these tricky issues will come up, but that it will be a very straightforward either deed transfer or estate planning case. Thank you all so much.
Thank you.
Thanks, Lindsay and Eli.
Thank you.